Attorneys of Reddit, when has a client's ego gotten them in trouble during court? Literally every time. I sat in a criminal court every day for a year, and more than 75% of those who were found guilty would not have been there if they had exercised their right to remain silent. Also saw a guy who wanted to exclude evidence that he was a member of a gang, but got his motion denied because he had the name of the gang tattooed on his face. Edit. Another one. A woman repeatedly said she couldn't remember various things and said she was on a medication that affected her memory. People not recalling things is pretty common, but they usually don't have a reason like that. Didn't turn out so well when the government played a wiretap of her saying she was going to claim she didn't remember and blame it on her meds. I don't remember saying that, cause, yeah no, the meds. I had a kid on probation who denied any gang involvement to the judge. She was crafty and had him raise his right hand again, and the name of the gang was tattooed on his arm. Do you swear by the name of the gang tattooed on your arm to tell the truth? Classic. I saw a video of a girl who had a $5,000 fine flipped off the judge, so he increases it to $10,000. When he tells her this, she tells him to F off and then gets 2 months. This should really not be legal. This essentially makes the penalty for insulting an individual $5,000, which is absurd. There should be no penalty ever for giving anything the finger. It's impossible to view it this way. There is likely a maximum penalty that she had not reached yet, and her poor behavior in court suggested she was not worthy of a smaller fine. We accept it because we consider that generally the court must be respected and there is a certain level of discretion afforded the judge. That said, this is a clear retaliation for speech by the government. It can't get any simpler. She voiced an opinion, and she was punished by a representative of the government for that opinion. That said, the judge does need the discretion, but it should be for things actually done rather than speech. If she physically or verbally threatened the judge or his family, for example. Contempt of court is a thing. I'm pretty close to a First Amendment absolutist, but your freedom of expression does have limits. If they are preventing the case from proceeding by interrupting constantly, that's one thing. But if they swear at the judge, and that's it, the judge needs to have thick skin and move on with their life. This type of fine is petty. Yes, that is, if you ignore an order. Criminal defense attorney. Basically every defendant I've ever represented. Sometimes it's stupidity mixed with an ego. Bad combination. They always think they can outsmart homicide detectives. Those cops have been practicing interrogation skills for longer than the accused has been on earth. So many cases turn on a dumb statement to lie instead of invoking right to counsel. Often they'll want to talk over the judge and a prosecutor when a ruling is coming. That never ends well. You get a lot of these guys saying I'll just go to trial. They'll have to give it to me, i.e. life sentence after trial. Yes, sir or ma'am. They can and they will. These defendants think prosecutors and judges are bothered by going to trial, or will cave with a plea at the last minute. Sometimes it works out for them, but that's a real dangerous gamble to take. Defendants always come up with the dumbest, weirdest logical arguments that somehow make complete sense to them. If it's a deadly weapon, how come I shot him 3 times? With a lot of the lower level offending we come across, we've actually found that defending charges and going to trial works out pretty well for the client. A lot of the time, the prosecution will either get to the day before the trial and want to do a deal, or drop the charges altogether. They are just not staffed to give all the criminal files the attention they need, so they often don't realize that there are issues with their case until quite far down the line. If our clients had plead guilty at first opportunity, they would have faced a lot more charges and a harsher penalty than pleading not guilty. True. I had a client who got bailed for criminal trespass, MIP, assaulting an officer, and possession. He insisted on going to trial. The day of the trial, the other offered a deal where my client would plead guilty to one of the charges in exchange for the others to be dropped. He chose the MIP. Obligatory. I'm not an attorney, disclaimer, but I did used to volunteer for a local program called Teen Court. It was run by the local city courthouse and allowed teenagers who were facing charges for misdemeanor crimes to go through teen court as a diversion program and receive rehabilitation classes and community service rather than time in juvie. The charge would also not go on their record. Teen court was run by local teenage volunteers after consideration and interviews, and it had an 82% rate for the defendants of never reoffending, which was double the rate for those in juvie in the city. I had one defendant once that I was representing who was an avid skier. I always encouraged my defendants to make a personal statement so that the jury might connect with them more, recognize their sincerity, and go easier on them. The jury has the ability to give up to 100 community service hours, but they don't have to give any at all. Oftentimes how the personal statement goes greatest affects the time given. My defendant didn't even stand for his, and simply said just know that whatever time you give me is going to cut into my skiing time. He was given 100 hours and multiple classes which probably added another 20 to 30 hours on. Oh look at Mr. Important over here, has all the time and money in the world to ski. Guess has got plenty of free time to do some volunteer work for a bit. Teen jury, probably. Slightly different scenario, but I like telling it anyway. A colleague of mine was in a family law matter. The father was the other party. He had extreme anger issues that, for obvious reasons, he tried to keep under wraps. Cross-examination begins, and my colleague has decades of experience. These issues will be made known. Plus, my colleague is a woman. He does not like women. Leading questions begin, and in no short order, he erupts. He gets out of his chair and tries to pick it up to throw at my colleague, but it's bolted to the floor. No wonder why. No further questions, Your Honor. But somebody I know personally admitted in court to having broke into abandoned real estate to live because he couldn't accept that he had no address. Primary residence was homeless. Hot. Anal, brought to you by Apple. Never leave home without it. Can't wait for the wireless version. Brought to you in partnership with Rictix. Already exists. Anal Apple iPod subwoofer. By he couldn't accept. Do you mean his potential employers couldn't accept? Because that's a very real stumbling block for someone in that situation. Not having an address makes getting job and even government assistance harder. I watched a dude named Nathan Jessup get goaded into admitting to a crime while on the stand once. What's his name gotta do anything? He's a character from a fictional movie called A Few Good Men. It's an irrelevant comment. There is a Philip Jessup who was a real attorney though. The world's largest moot court competition is named after him. In case someone wanted to research the case. Colonel Nathan R. Jessup, commanding officer of Marine Ground Forces, Guantanamo Bay, Cuba. I'm an attorney, but currently work as a judge's clerk. You have every right to fire your attorney. You can threaten to fire your attorney at any time. Threatening to do so loudly during voir dire, the time when all the potential jurors are present, is generally not the wisest time. Why? You generally want to appear united with your attorney as they are your advocate. And when the first thing jurors see is you clearly having a major disagreement with them, it gives a terrible first impression. My father was a public defender and defending a man on trial for arson. A witness said something unflattering about the man she had seen, and my father's client jumped up and shouted, "You can't talking about me like that, Imlawi the Torch." World's worst supervillain. This is easily my favorite. You see, it's an ironic name. You know, like Jimmy No Nose. He got a big nose. You know how it is in the mob. Usually when they insist that they want to speak to the judge directly, you might as well hand them a shovel after the first "let me talk." Every single time. Especially in family law, though it happens constantly with my criminal clients too. It's all ego and emotion. I understand why, but step back from the situation and listen when I say you're going to regret making all of your legal choices based on spite. When I was on a jury, the defendant argued that he couldn't have known he was stealing because he apologized to the person he was stealing from before he left with the guy's stuff. So not an attorney, and definitely not this guy's attorney, but Marshall Nee was tried for treason after Rolled Boney was beaten. His attorney tried to claim that Ni was technically not a Frenchman on account of the fact the Prussians had just annexed his hometown. Ni, enraged, declared that he was a Frenchman and would remain so. He did, however, manage to gain the distinction of one of the few people who have the honor of commanding their own firing squad. Was at an internship in court and saw the defendant stand up in the middle of the judge talking, shouting, and walking out yelling thanks for nothing. Attorney-client privilege. I'm bound from disclosing any sensitive information to you guys. Sorry. Then why did you post anything to begin with? That's not how attorney-client privilege works.